Hello, everybody. How are you? Hope everyone's doing well tonight. All right, I wanted to talk about the state's brief in the Adnan Syed case. I'm going to do something right now that's going to sound like terrible self-promotion, but there's actually a benefit to it because I want to know who the audience is. First of all, thank you for the hearts. I'm going to ask you to stop the hearts for a second. You know why? I want to see who's a lawyer and who isn't a lawyer. So I'm going to ask, who are lawyers? So do some hearts if you're lawyers. Heart if you're lawyers. Okay, we don't have any lawyers here. Heart if you're not lawyers. Okay, so basically non-lawyers. Isn't that interesting, first of all? Why is it that non-lawyers are so much more interested in this case than lawyers? I think it says something about our field. Seems like as lawyers, we're not interested in human drama. Dare I say justice? And that's the thing that strikes me, looking at the prosecution in this case and on appeal. They really don't seem personally interested in what happened. And I'm going to get right into this, but I want to get in the head of them for a second. Maybe it'll help you, maybe it'll help me understand what's going on. In a former life, before I was in Minnesota, I worked in the California Attorney General's office in the correctional law section. And I defended the state and people employed by the state, including like the governor and stuff like that. It sounds more glamorous than it is. From lawsuits brought by prisoners. And the work was very interesting because a lot of these, I should say, were constitutional lawsuits. So First Amendment, things like that. Some of them were kind of funny, I have to say. Like one involving the type of magazines that prisoners could get, whether they could contain nudity. Others where people were saying their freedom to associate with other white inmates was infringed upon. Anyway, there was a lot of different stuff. But what I'm getting at is the one really case that at least was big for me, that changed my life in a lot of ways, was one I worked on there, and it was one involving what's called gang validation, which is where an inmate, and I'm going somewhere with this, so an inmate, if they were validated as a member of a gang, a prison gang, they would essentially be put in segregated housing. And if they had an undetermined life sentence, like 15 years to life or whatever, essentially they're never going to parole. So you could get locked up as the guy who was on the other side of the inmate in 1985 for a second-degree murder, and he's still locked up because he got validated. His co-conspirator, the person also involved, was out like in 7 years. So there's a real argument of being very unjust and all that stuff. And so I'm going somewhere with this. Yes, where I'm going is sometimes the evidence that these validations are based on was not very strong. And I was working on it, and the argument was whether or not this guy, not his day in court, whether or not he even really got a real hearing administratively in the prison. And the big top 25 law firm that was representing this inmate pro bono and throwing lawyers at and whatever said he didn't. And we were saying he did. And my feeling throughout was, well, I don't know about this evidence, how good it is, whatever. But I think this guy's a gang member. I think he is. And so what I say is that I was sort of uncurious about what was really going on. And I say to the detriment of my own side. I'm going to say this honestly. If I really was interested in finding out what was going on, it would be better. A quick recap, please. Oh, yes. The recap of what's going on? Yes. So the motion we're talking about is the state's opposition to Adnan Syed's motion to reopen proceedings to hear new evidence at the trial court level. Okay, so I'm going to get onto that. And so I thought of that because this guy, and I'm going to butcher his name, the guy who wrote the brief, who talk about a pedigree. So this guy, Thurvinden Vignarahaya, I'm sorry, I'm not trying to be mean. He's Sri Lankan descent, went to Woodlawn High School, as Colin Miller pointed out, graduated in 1994, went on to Yale, Harvard Law, oh my gosh, medical ethics in England. And where the gang member part comes in, and I just want to say this to show his background, is he took down a prison gang called the Black Guerrilla Family, which started out, I think, in the 60s as politically radical. It became like any prison gangs. based on that. Yeah, the gang member, I was just making, someone asked about the gang member. I was making a connection to my experience that the prosecutor, not part of serial, that the prosecutors seem very not interested in what really happened in this case. And I'm trying to show kind of psychologically how someone gets in that place. Because I think for a lawyer, and maybe especially non-lawyers, it seems odd. It seems like they'd want to know what happened. Okay, so the guy who wrote the brief, as I said, a background, he's major crimes, took down some pretty bad folks. Thanks for the Bluetooth. Took down some pretty bad folks in a prison gang. And prison gangs are pretty nasty. Much worse than regular gangs. And they tend to run regular gangs on the streets. Okay, so with that said, let's just see some feedback from people. Let's see. Feedback. Well, I will say one thing. Let's get started. The background of this is that the state is trying to keep Adnan Syed from putting new evidence in front of the court, because when a case is on appeal, the evidence that the appellate court can hear on appeal is what's already there. So if you've noticed looking at this, when there's citations to the record, it's citations to stuff largely that's already been before the court. There's some exceptions with the motion to reopen. There was some new evidence put in, including the cell phone stuff. So that's where we're sitting here. So let's just look a little bit at the brief itself. I just want to say a few good things, and actually things that from a legal writing standpoint are good, and say something good about Adnan Syed's case. This is really well written. I mean, we can argue about how it's argued, but it's really well written. Even the font's really good. It's in Garamond, which is what I like to use. A lot of times we use Times New Roman, which looks pretty terrible. So they use a really good font. They have an all-star guy, the writer, superstar, and they put a lot of time and money into this. I mean, this is the best they've got. So what this means is, for all you, Judge Eaton. Oh my gosh, who is that? My brother. Sorry, I don't mean it. My brother said something, an inside joke about a retired judge I used to work for when I was a kid. So, it's really well done. A lot of time went into it. This is obviously a top priority. And this motion was not just for the court. It was for the public, I really think. And as we look through a few things in this that the state said, I think you'll see where that comes up. As a rule of thumb, I'd say, one rule of thumb, that if you're reading a brief, a motion, an argument made by a very good lawyer and a very smart lawyer, and it doesn't really make sense, but it gives you an unsettling feeling that you can't really pinpoint and you don't know why it doesn't make sense, that's probably because it's for another purpose other than the argument being made. And that's, I think, where the cell phone records come in when they talk about that. So I'm going to go through here. If you want a really good legal analysis of it, go to the Evidence Professor blog, Colin Miller. Very good. And he's very scholarly and looks at all the cases, and I love it. But that's not really what I do. That's not why you listen to me, because he's better at it. But what I look at is the tone and some of the persuasion techniques that are going on in this. So let's go right through this. I got to talk about this alibi witness stuff. Let me see. What page is the alibi witness stuff on? Because I want to talk about how much this annoyed me. Yes, okay. So we start talking about the alibi witness. Well, the main part is on page 15 of the brief. So the state's argument is, okay, so let's assume that Christine Gutierrez, Adnan's defense counsel, didn't contact this alibi witness. She could have not contacted him and been the greatest lawyer ever. What is it? A seasoned and accomplished lawyer. First, another rule of thumb in law, if your opposing counsel is saying you're doing a good job and are a good lawyer, you're probably not doing a good job and you're probably not a good lawyer. There's a reason. So if, as I was in the experience in the case I was talking about of losing a case, that's a civil rights case, a civil case, and the other side's entitled to attorney's fees and they win. They do their attorney's fees motion saying about why they're entitled to all this money from the state. And they're going to say you're the greatest lawyer in the history of the universe, which justifies why they had to spend so much money and have 5 lawyers at a deposition. So you're in bad shape if the other side is praising you. You know, they're damning you with faint praise. So here on page 15 is where it gets in the meat of it. This 80 potential alibi witnesses. So Cristina Gutierrez, here's the background. They're saying that an odd argument that I'll get to later about how we can, because Cristina Gutierrez was investigating alibi witnesses, we can assume that she investigated Asia McClain, even though she maybe never contacted her. It's the odd argument. Here's the part leading up to it. So how have we come? What are we saying in support of our argument that Cristina Gutierrez did all this work on alibi witnesses? Because she sent this letter, which I found. It talks about October 5th, 1999, to the prosecutor, talking about the alibi witnesses. And I know it's here on the motion. I just want to read it out loud so you see the entirety of the letter. Dear Mr. Urich, these witnesses will be used to support the defendant's alibi as follows. On January 13th, 1999, Adnan Masood Syed attended Woodlawn High School for the duration of the school day. At the conclusion of the school day, the defendant remained at the high school until the beginning of his track practice. After track practice, Adnan Syed went home and remained there until attending services at his mosque that evening. These witnesses will testify as to defendant's regular attendance at school, track practice, and the mosque, and then his absence on January 13th, 1999 would have been noticed. So, and there's 80 people, most of whom we've never heard of. Mostly, as I could see, people with what we would consider associated common Islamic names like Ahmed, Muhammad. Let's see, is there a Miriam? I have a daughter named Miriam, so I always look because I know it's a common Islamic name as well, although the name originally is Hebrew. All right. Well, anyway, so that's a sum total of their evidence that there was this big investigation going on. And I just have to say, practicing law, that means nothing. That it is customary in law, in pretrial disclosures, evidence lists, trial exhibit lists, witness lists, to throw in everything in the kitchen sink. It doesn't mean anything that you have a name there. So that's a silly argument because, as Colin Miller pointed out, so there's 80 alibi witnesses, and Cristina Gutierrez calls one at trial, Adnan Syed's dad. So of the 80 witnesses, many of which we know would have been helpful to Adnan, she calls one. And they take that, so that's the raw material to the argument, and they take that to conclude that Asia McClain, who would be the 81st witness, okay, that goes to show that she was contacted or considered. So here we go. And where a seasoned defense attorney, watch out, seasoned defense attorney, means something bad's going to happen that's going to hurt Adnan Syed, like Gutierrez, generates a list of 80 potential alibi witnesses, it is reasonable to conclude that some inspection of the 81st alibi witness was performed. I don't think it's reasonable to conclude that. And someone says, why would you call a family member bad form? I would agree too. I mean, I'm not a criminal defense lawyer, but in my experience, you know, they call a family member when the only one who's going to stick up for Junior is mama. And that's not the case here. You know, there's people who had real evidence supporting his alibi. So that's really interesting. So the state's argument is that because she sent this letter and identified 80 people, we have to assume that her decision to call one of them at trial, well, first of all, that meant anything, and that her decision to call only one of them at trial was tactical. Okay, so that's how we get the 80 witnesses. And there's been talk about how she did a terrible job by not calling others. And then we go from there to the next argument that her decision not to even call or name or do anything with the 81st witness was good. And so, if someone said ineffective assistance to counsel for calling that, I don't know about that. I haven't actually looked at that part of the hearing transcript. I've looked at the rest of it, but I haven't talked about that. So I wanted to talk about that. I'm going to talk about a few more things, and I can be on for about 16 more minutes, and then I'm going to ask you what you want to talk about. So let me just go through this before I forget. Another thing. Okay. There's talk about how the prosecutor said that Adnan told the police that he stayed at Woodlawn High School right after track practice, through to when track practice ended. And Colin Miller pointed out, and so did the supplement, I believe, to Adnan's Syed's motion to reopen, that he never said that. So where did that come from? Well, it came from, as far as I can understand, this letter, the same letter we're talking about from October 1999, that Cristina Gutierrez sent Uric, saying that, their alibi defense, in essence, was that he was at Woodlawn High School. And, Colin got more into how that works factually and whether you can do that. But I just wanted to comment that I'll say in the prosecution's defense, or the state's defense, is that it's a common thing that happens in cases and in life when something that has no real evidentiary basis becomes enshrined as a fact. That's why we have the rules of evidence. That's why we have prohibition under certain circumstances of uncorroborated hearsay and other things, because we want to make sure that what seems is entered into evidence as a fact actually is. So as I see it, this letter was out there, and that became a basis to say, well, the defense claims or alleges this, and it became treated as a fact by the court. It is today. And, so in defense, again, of the prosecution, possibly, is they might not be acting in bad faith by saying that. And they might think it's fair game because it's sort of an argument the defense made. And just to give an example of how this happens is in cases all the time. And I like to say this because it doesn't involve blame on me. I've had cases where other firms have handled before and we've gotten them, and there's stuff in the case summaries that they've sent to the clients, and you think, well, that seems really good or that seems really bad. Let's find out where they got that from the deposition transcript or wherever, and you can't find it. But it's been in the case summary, somehow it got inserted, and it's become a fact. So you have to go back kind of the beginning. It's hard to do. And I can just say a personal experience of that happening is to my wife, who has had medical issues and had a stroke, and she's doing okay now. But someone, when this happened, diagnosed this as like a conversion disorder or something really odd that it didn't fit. And there wasn't really much evidence for it. But it became part of the summary, and I'm guessing, I haven't seen the medical record, I bet it was like the first thing that was put in the summary. So every time we go to a new doctor, someone would say, well, what about this conversion disorder? I think there's no basis for the conversion disorder. The neurologist said no. It just somehow got inserted somewhere into the medical record, and, someone said that was the case. And one other thing, just to give you an example of how that would happen, is when we were meeting with the neurologist, he was pointing out how medical records mistakes can happen. And he said he had someone come to him, supposedly had tumors in her head, and they found out, he couldn't figure out where they got this, and it found out that someone had written, and this is when everything was in writing, had written tuber, which was the person's last name, and someone thought it was tumor, and from then on it was tumor. And so it wasn't until he did his own investigation that he found out what the real fact was. So that's just something that interests me that came up in here. Okay. Excuse me. Please forgive me for that. And the final thing that struck me as odd, and I was bothered by, again, trying to give the state every benefit of the doubt, is this thing about the timeline. That the prosecution seems to have this idea, and Uric did. If you look at his interview, he said, well, Jay's story kept changing, but what stayed the same was that Adnan did it. And you think, that's enough? So we just have to have someone be at the stand at trial and said, this guy's your guy, and that's all you need? That seems to be what they're saying. That, more specifically, they're saying that this wouldn't matter. The Asia McClain witness wouldn't matter because she puts Adnan, assuming we believe her, assuming the court believes her, assuming the jury would believe her, this puts Adnan at the Woodlawn Library School / library at 2:23 p.m. So that would mean that the state's timeline that has Adnan making the come and get me call to Jay at 2:36 couldn't be right. And what the state says is that, well, we could just change the timeline. We could have just changed the timeline at trial and Adnan would still be convicted, which I guess is true, but that just seems, that's an argument that makes me very uncomfortable. The idea that they can just mess around with time, and that's what they did at trial, because the problem is, and something that could be said in defense of Cristina Gutierrez and who she called and who she didn't call, is as far as I can understand, well, I'll back up. She would have known, well, no, I think, yeah, weak sauce argument, I agree. I think they didn't know till closing arguments that the prosecution was arguing that the 2:36 p.m. call was the come and get me call, because there was no evidence for it, and Jay had a different time. I mean, it was something, that also makes me uncomfortable, that the prosecutor just put together at closing argument. So the idea that, oh, this witness, sure, it would destroy this timeline, but we'll come up with a new one. Well, where does it end? Every alibi witness that destroys a timeline, then we just find a new argument and hope it sticks. That's something I think everyone should be pretty uncomfortable with. So anyway, that's all I've got to say. I talked longer than I intended to, and I got about 9 minutes. So I want to hear anything you want to say, if you've got anything to say, and maybe I could respond to it. Also, if you don't know, I'm making announcements for Serial Season 2, which is going to be about something else altogether, the main Serial podcast that started all this. I'm starting a podcast called the Serial Lawyer Podcast. It's going to be following along with Serial Season 2 and doing a lot of other very interesting stuff. So I'm one of the lawyers. There's 2 others in the Twin Cities area. Do you think Adnan will ever get out of prison? Yes. I think, this is not a legal opinion, it's the same opinion as the rest of you, that it's going to come out and eventually he's going to get out. Can theory of case change during trial? Yeah, I mean, okay, I'm not a criminal defense lawyer. What strikes me is, how does that even work? I mean, that's the thing I sometimes wonder in this prosecution. How does it work that, and someone asked about theories on Don, so I'll write that out. How does it work that you actually get a jury to convict when you change your theory? I think it's because the case was so convoluted, people didn't remember what was said at the beginning. Cell phone records, okay. And here's the thing that bothers me about the prosecution case and about a lot of lawyers' cases, is based on little evidence, we think we can say what goes on in someone's mind, and you can't. That snippet in the first Serial where the prosecutor wasn't Yurik, it was the other one, who was saying what was in Adnan's mind when supposedly he killed her, that's just ridiculous. And I would think the jury would be like, you don't know what was in his mind. And if the defense was better, they could have built some empathy, and people wouldn't believe that, I would think. And someone said, guess it's fine if the jury believes it. And that's an attitude that people have. That, well, if the jury convicts, it's fine. Is it normal for a witness to change the story so much? No. No. Not at all. And the problem is that Cristina Gutierrez did do a bad job, but she did a typically bad job on cross-examination, is she tried to argue with the witness. And this is just my thing, people disagree. You just need to establish facts. Simple sentences, one fact per sentence. I actually did if you look up me on YouTube, I just did something. It was just on the fly, but I did a mock cross-examination of Dawn and of Detective McGillivray. I'm saying that name wrong. And so it was a few months ago, so I didn't know the new Dawn stuff, but I just used it to establish that the police investigation of him was bad. Okay, theories on Dawn. Oof. First of all, big shout out to Bob from Serial Dynasty. You did a great job. And anyone who helped Bob and is helping Bob, kudos to you. I mean, the work that people are doing behind the scenes in this is I'm just so excited about it as a person, as a lawyer. And it's so encouraging to me that people in their own lives are thinking about this and doing something about it. It's wonderful. So, I mean, give yourself a round of applause, whatever you do when you're on Periscope. Good job. Theories on Dawn. I don't like to talk about, other suspects and everything. I've always felt really uncomfortable with Dawn. And this whole thing about him, his personality, and him being kind of emo, big red flag for me when I read in the transcript back when Susan had it, when she did the thing on Dawn, I think in March, about Debbie, Hayes' friend, having a 7-hour-long conversation with him. 7 hours. And just a random person. I don't know Dawn. It seems like he's working on her. Doesn't that seem like to you? And that a lot of these ideas about her and Hay in California came from him. Weird. But things are weird. Weird things happen, right? The guy who wrote this brief is a graduate of Woodlawn High School. You know, that's kind of weird. Yeah, someone says huge red flag. Yeah, I mean, there's lots of red flags. I mean, here's the other thing. Things can be weird. Someone can be weird. Someone could be what we'd think of as a bad person. And that doesn't necessarily follow that they're a murderer or follow that it comes to the conclusion we want to. You know, I mean, you have people who, for whatever reason, mentally, nature, they don't respond emotionally the way that the rest of us do, or we think we should. And people come up to all sorts of stuff. And, you know, they go from there, you know, and make conclusions that aren't founded. You know, someone said, so Assistant AG knows the library is part of the campus. Yes, he would. And the idea there is that the state made a big deal about the library being somewhere else. People really are interested in Dawn, so I'm going to continue with Dawn. Didn't Dawn assault Debbie? I don't know where that came from. See, that's some of the stuff that's weird about the notes the detectives made. They made notes, and I wasn't able to really follow this. I didn't put enough time, but someone on Reddit, and a reputable source on Reddit, without giving too much detail, and those exist, said that there were certain notations in the note which indicate when the officer was actually quoting someone and when they were actually putting their own thoughts. And so I don't know the whole assaulting Debbie thing. I could have just been a rumor, you know. So we don't really have any evidence of that. But I hope people are looking into it and thinking about it, because I'll put it this way, and I'm going to have to get off in about 2 minutes. It's a really worthwhile line of inquiry into Dawn. I don't know what to say other than that. I've been re-listening to the main Serial podcast in preparation for the one I'm doing, the Serial Lawyer podcast, which more information will come out in the next few weeks about. And yeah, the Dawn thing. I want to know. Okay, so this is the last thing. How difficult is to get new evidence in? Attention cover sheet. Does Brown get a Brady eventually? Yeah, it's hard because once you lose at trial and you're on appeal, you're pretty much stuck with the appellate record with some exceptions. So there's a lot of things that are going to happen. Oh, I'm going to kill you note. So, okay, this is the last thing I'm going to talk about. Someone talks about the I'm going to kill you note. And a few months ago, I had some frustration that no one seemed to be talking about the I'm going to kill you note. What is the I'm going to kill you note? It's the note that was written on a note that apparently was between, okay, it's like 3 degrees of hearsay, right? It's like hearsay. So you had a note that supposedly was written from Hay to Adnan. Adnan is writing on that note a note to another student whose name I'm forgetting, who's a friend of his and a friend of Hayes. And on the back, it says, I'm going to kill. And someone pointed out, it doesn't say you. Well, we're assuming it's in Adnan's handwriting. The state did mention that it was in his school book, wrapped up, folded up, which I think is a good argument for it not being something he was even thinking about, because that was my thoughts. Like, where was this found when they searched his house? Where was it? Was there like a bullseye on it and blood? What's the context? So I think it's nothing. I think it means nothing. It's one of those things. And I'm not one to criticize anything about Serial. I'm a gigantic fan. Like, I will defend it I like everything about the Serial podcast, like everything. But the part when Sarah says, "Oh, this whole I'm gonna kill note," it sounds like something like sappy from a cliche. I just thought, I don't care if it sounds cliche. Let's get into what's actually there. So that was very frustrating to me. I wish that they had gotten more into that and we could just have put it to rest. But I don't think there's anything to it. I got to get off Periscope. And so anyway, find me on @Kenny, @KENNY, Brendan, BRENDAN on Twitter. And also for that new podcast, everything else isn't up, but the email is up. The Gmail account is going to be serial, SERIAL, lawyer, LAWYER, @gmail.com. So email me if you have any questions, any comments, if you want to help out. We're going to be starting fan groups on all the social media. I'm going to need all the help I can get. And I'm not talking about money, I'm just talking about getting the word out. And eventually, if anyone can help with editing podcasts or anything, we've got an announcer, we got some music, we got things like that. But we're going to need help with editing and getting the word out. And so just email that serial lawyer, SERIAL lawyer, LAWYER, @gmail.com with anything. That's the main point of contact. Of course, you can get at me on Twitter too, but that's probably the best way. So have a great night, everyone. Thank you for your interest and, the hearts and retweets and all that kind of stuff. It means a lot to me that people care about this because, well, I won't say I'm obsessed, but I think about it a lot. Have a good night.